that sentence implemented, he walked himself to prison. The procedure of going to prison is clear. Once you have been sentenced, you are arrested. Once you are arrested, committal bundles are signed, are brought from prison. They are signed by the magistrate or the judge committing you. Then those committal bundles are the ones that will admit a prisoner in custody. This is a replica of my client's case again, when George Kinoti, the DCI, was also sentenced and told to walk to committee prison. It never materialized. It is academic. The prison authorities don't receive visitors who will say, we have been told, we have been sentenced, open the gate, let us get into the prison cells. That is a serious anomaly, and that is a politics that you can see, that the conviction and the sentence of one Masengeli is political. Two, when you look at the question about the Minister for Interior being ordered that in the event Masengeli does not go, then he has a duty to bring him to prison. The Minister for Interior has no police powers of the state. He's a civilian clothed with the power as the Minister for the Interior. He cannot arrest. Powers of arrest are conferred on the National Police Service Commission and the agents, that is the police officers. So that is why I'm saying the second limb tells Kenyans that there is a lot of political witch hunt. Masengeli comes from Western Kenya, the Luhya Nation. This is the first time that that position has fallen outside the regions where the position of then Commissioner of Police, now the Inspector General of Police, for the first time, the position, if the current substantive head does not make it, then it will go to Western. So there is a serious political witch hunt. The sentence is purely meant to blackmail Masengeli if he succeeds to get the position, but if that position is vacant. When you look at the ruling, the sentence was suspended for 7 days. And the court surprisingly says that he can redeem himself by appearing before the same court within 7 days. The law is very, very settled. Once a judge or a magistrate has sentenced, by law he becomes functus official. He cannot review his own sentence. Masengeli can only move to the Court of Appeal to vary, to set aside that sentence. So that order of the judge is not based on any known law. We shall be moving with speed on Monday morning to the Court of Appeal to set aside those orders, so that, because the orders do not have any basis in law, they do not have any precedent that have been set, they are orders that cannot be implemented, and that is why I have called the media for Kenyans to understand that this is not a criminal question. This is not about the law. This is the politics of succession of the position of the National Police Service, who becomes the Inspector General. Lastly, what comes out to the country now that the acting IG has been sentenced, there is nothing wrong. The law provides that anybody who is sentenced above 6 years is the person who loses his position. My client Waluke was sentenced, he went, he came out, he's still serving as a member of parliament, yet he has been convicted. So the law as it is when you have been sentenced above 6 years, 6 months, that is when you lose your position. What is the current position of the law of contempt? The contempt law was declared unconstitutional. What we are operating on is the Magistrates and Act, Cap 10, that is providing for reason on how to deal with contempt. So we shall be moving to the Court of Appeal with speed to restore sanity in the country. My appeal from my client is to the whole nation to be settled that there is nothing that stops the acting Inspector General of Police to discharge his mandate. All organs of the National Police Service are in place, and the security apparatus have their centralized command in the acting Inspector General of Police, and the